In this lecture, we shall treat management of family property. Management of family property. Management of family property. And under this, the first thing we'll look at is how do we acquire family property? How do we acquire family property? After identifying how we acquire family property, we shall also look at how do we alienate family property. How do we alienate family property? And then after looking at how to alienate, we will then come to litigation in respect of family property. Litigation in respect of family property. Who has the right to litigate? How do we litigate? We'll look at litigation over family property. And then we will look at appointment or election or removal of head of family. Appointment or removal of head of family. And then we'll come to accountability of head of family. Accountability of head of family. So these are the main things that we'll treat in this lecture. So the first part deals with acquisition of family property. Acquisition of family property. Now, the first thing that we need to note under acquisition of family property is this. It is the general rule. It is the general rule that when property has been acquired with family resources, so for example, when property has been acquired with resources from the family, like income from existing family property, or when a family property has been sold and the proceeds have been used to acquire another family property, then the property thereby acquired with the family resources, such property will be deemed to be family property. Such property will be deemed to be family property. That is the general rule. It means that if the family has an account and then money is taken out of that bank account to acquire a land, the land that is thereby acquired becomes family property. The land that is thereby acquired becomes family property. Now, the next principle is that when you have a property and this property has been acquired, it has been acquired by the joint efforts of members of a family. It has been acquired by the joint efforts of members of the family. Then the law says that there is a rebuttable presumption. There is a rebuttable presumption that the property acquired by the joint efforts shall be a family property. Shall be a family property. So when you have about 20 people in a family or 15 people in a family who have come together to acquire a property, an immovable property, the law says that there shall be a rebuttable presumption. There shall be a rebuttable presumption in favor of family property. Please, all we are discussing in this lecture relates to acquisition of immovable property by families in Ghana. In Ghana. So, as we have said, where property is acquired through the joint efforts of members of the family, then the law says there shall be a rebuttable presumption that the property thereby acquired is a family property. Now, if about 10 people in a family bring money together to acquire a property, by this principle, what we mean is that there shall be a rebuttable presumption that the property that has been acquired is a family property. So remember, it is a rebuttable presumption. So that can be rebutted. It can be rebutted when, for example, you have a document showing that the 5 7 or 8 people who acquire the property signed that they are acquiring this property for themselves. In that case, the property that has been acquired by the 8 people in the family will not be deemed to be family property. Now, generally speaking, when about 8 or 9 people bring money together to acquire property in the family, as we have said, it is only a rebuttable presumption in favor of family property. But what happens when one of the acquiring members dies? The law says that if there are 8 people or 9 people or 10 people in the family who have brought their money together to acquire property, there will be a presumption, a rebuttable presumption, that the family will be deemed to be, the property will be deemed to be a family property. Now, when one of the acquiring members dies, the surviving contributors, they will only retain a life interest, and the property that has been acquired, it shall become a full-fledged family property upon the death of the other contributors. So generally, the people that brought their money together would have a life interest. When one person dies, the surviving people would also have a life interest until the life interest of the last survivor is extinguished. So when there are 8 people, when the first one dies, the remaining 7 will have a life interest. When the next one dies, the remaining 5 will have a life interest, and that will go on until the last contributor dies. That is when it shall become a full-fledged family property. And that is the case of Chechewa versus Aqua. Chechewa is spelled T-S-E-T-S-E-W-A versus Aqua, A-C-Q-U-A-H, 1947, 7 West African Court of Appeal, WACA, at page 216. On the next principle, when a member acquires property, when a member of a family acquires property with a small contribution from the family, then the family does not own the property that has been thereby acquired. And so when a member is building his property and the family brings just a small contribution to add to it, that property that has been thereby built, it shall not assume the nature and character of family property. And so if I am building my property on my land and the family takes an amount from the family account, and my house costs about 1 million Ghana cedis in all, and the family brings about some 5,000 cedis from the account and comes to add up to buy some blocks for me, the property I have acquired, it shall not assume the nature and character of family property. It shall still be deemed to be my individual self-acquired property. And that is the case of Cudjoe versus Kwache. Cudjoe is spelled C-U-D-J-O-E versus Kwache, K-W-A-T-C-H-E-Y, 1935 to West African Court of Appeals at page 371. Now, the third principle applies when a member of the family has benefited from financial support from the family through education. So let's say that when you were growing, your whole family used to consistently take monies out of the family accounts. Then they used it to pay your fees. You realize you're going to law school. Then they also went to sell their family house and use the money to pay your fees. So when a family member benefits from financial support of the family towards that family member's education. Properties that have been acquired by such members of the family who has received the support, the properties that have been acquired by that member in future, it shall not be deemed to be family property. It shall not be deemed to be family property. I know by now some of you are wondering, but this is supposed to be straightforward. Yes, but you'll be surprised that there has been a suit in relation to this. Labi and Ketu. Labi and Ketu. Labi versus Ketu. Labi is L-A-R-B-I versus Ketu, C-A-T-O. 1960 Ghana Law Reports at page 146. 146 is concerned a person who received support from the family, and then that person eventually became a lawyer. Now, this lawyer, when he died, it was realized that he had given the properties that he had acquired to his son in his will. And so when he died, a member of his family then brought an action against his son who he had given the property to, and then his widow. So when he died, his brother brought an action claiming that the property that had been acquired by him when he was a lawyer, such properties should be family property, and it should not be property that would belong to the child and the widow of the deceased. And what did the court say? What did the court say? What did the court hold in relation to that? The court held as follows in holding one, that the customary law of Ghana that does not impose upon sons of the family who have received a professional education with the support of the family an obligation of repayment, nor do the earnings of such sons upon themselves attain the character of family property. Attain the character of family property. Yes, so that's the case of Labi and Ketu. So when a family member benefits from financial support and he acquires property through that, the properties he has acquired shall not become family property. Shall not become family property. Such properties will be deemed to be the personal self-acquired property of such a family member. That is what the court held in Labi versus Ketu, 1960 Ghana Law Reports. Now, there is an interesting point that was made by the judge in Labi versus Ketu, Granville Sharp DE. He made an interesting point at page 152 of the report. Now, when you read that portion, it creates the impression that when a member of the family is building his own house and such a member goes to seek assistance from the family. So let's say a member acquires a land, he starts the building, and then he goes to the family account and they collect money from the family account to come and complete it. Or they go and sell the family property and they use the proceeds to come and complete his house. The judge gives an indication that it is possible for such a house to become family property. This is what the judge said, and I quote at page 152 of the report, that we do not doubt for one moment that those family members who make contribution to the building of a house are entitled to share the enjoyments of the building. But this is and must be on the basis that by accepting support and contribution from the family, the builder recognizes that he's building a house for the family. That he's building a house for the family. And the judge goes ahead to say as follows: that if the family as a whole is in fact assisting in the building of the house, it would not affect the situation if the contribution of one member was greater than another person's contribution. In such circumstances, the slightest assistance, which is to say contribution, would give to the provider an interest in the enjoyment of the house. Would give to the provider an interest in the enjoyment of the house. So if the whole family is contributing to acquire a property, that is what, so I'm explaining this now, what Danville Sharp G said. That if the whole family is contributing to build a house, then if I got 5,000 cedis, I'm entitled to share in the house. It doesn't matter that you pay 50,000 cedis, 10 times my contribution. If everybody contributed, it doesn't matter whose contribution is more than the other. So read Labi and Keto for such a scenario. Now, the next principle that we shall look at is that when a member of the family acquires land with his own resources and other members, they provide the funds to build on the land, the house thereby built on the land. That house becomes family property. So when one member of the family acquires land with his personal resources and other members of the family, they provide the funds to build on that land, the house becomes family property. And you see this in the case of Boafo versus Stout. Stout is spelled, Boafo is spelled B-O-A-F-O versus Stout, S-T-A-U-D-T. Now, the fourth principle. The fourth principle applies in situations where a member of the family acquires some money, and this member goes ahead to build on the family land. So the family has a land somewhere. You, the member, you go ahead and you build a house on the family land. The law says that the land over there remains family land. The land will remain family land, and the house that has been built, that house shall become family property, with a member only acquiring and retaining a life interest. And so if the family land is there and then you go and put your money there to build a property on that particular land, the land remains family land, the building on it too becomes family property. Now, what happens to your interest? The law says that you shall acquire a life interest in the property. You shall acquire a life interest in the property, and upon the death of the one who built the property, upon the person's death, the person's widows and children of the man, they shall have only a right to occupy the property, subject, of course, to being of good behavior. Subject, of course, to being of good behavior. That is the case of Emisa Abadu. Emisa Abadu is spelled AMISSAH hyphen Abadu ABADOO versus Abadu ABADOO 1974 One Ghana Law Reports at page 110. In this case, the court settled the law that if there's a family land and you go and build on that family land, whatever you build on it becomes a family property. But remember what the court noted about the surviving spouse and the children. The court held that the surviving spouse and the children, they have the right to occupy the property subject to being of good behavior. If you check the case and you look at holding 6 as captured in the head notes, you will see over there that the court has noted that where the deceased lived in the family house with his wife and children, the widow and the children had no interest save a right of occupation subject to good behavior. So that is the case of Emisa Abadu versus Abadu, 1974, One Ghana Law Report at page 110. Then we move on to the next principle, which says that when a member of a family, you make an extension to existing family farm, or you improve upon the existing family farm, then the essential character of the farm remains family property. The essential character of the farm remains family property. And that's the case of Nkonua. Nkonua is spelled Nkonua versus Anafi, ANAAFI, 1961, 2 Ghana Law Reports at page 559. Then the next principle, where a member of a family, you go and you extend or you improve existing family building. Such an improvement does not change the character of the building. The building shall still remain family property. And that is the case of Kuma versus Asante. Kuma is spelled Kumah versus Asante, ASANTE, 1991-93, 1 Ghana Bar Reports at page 328. And the next principle, when family property is lost, it is lost through sale, or it is lost through an attachment and then sale by the courts, and a member of the family goes to repurchase or redeem the property, that property becomes family property unless the member of the family at the time of redeeming or repurchasing the property, unless that member specifically informed the family that this repurchase that he's repurchasing or this redemption that he's doing, the property will not assume its former possession as family property. If you inform the family at the time that you are redeeming for yourself and not for the family, then it will become your personal property. But if you don't inform the family at the time and you go and redeem a family property that is lost through sale or other attachments, then upon redemption, the property resumes its character as a family property. That is the case of Nuonama versus Esiedu. Nuonama is spelled Nwonama versus Esiedu, Asiedu. And then we move on to the next principle. The next principle is that when you have a person whose social obligations, let's say a son, his social obligations will require him to assess his father, then when he assists his father. Any property acquired by his father is still the individual property of his father. So the rule is that where social obligations require some individuals to assist another person, then when such assistance is given, the property thereby acquired is the individual property of the person so assisted. And so when a child assisted his father or guardian to acquire property, that child did not become a joint owner of the properties that has been acquired by the father. And that is the case of Yoguo, Y-O-G-U-O, Yoguo versus Ejekum, A-G-Y-E-K-U-M, 1966, Ghana Law Report at page 482. When you take a look at the case, and then you look at the holding two, saying that by customary law, where a child or ward worked with his father or guardian, he did not become owner with the father or guardian of the income of their joint labor. Whatever came out of that joint effort belonged exclusively to the father or the guardian.